Welcome back, everyone. We'll call this meeting back in session. And at this time, I would like to recess for 45 minutes to allow the attorneys to confer for a charge conference.
Thank you.
Okay, we'll call this meeting back in session. And at this time, we will go into closing statements. Gentlemen, I'm so sorry. Before we do that, gentlemen, have you both reached an agreement on the charge?
Yes.
Yes, there's not a need for a formal charge conference.
Okay, thank you. And how much time, would 30 minutes work for closing statements for both?
I believe so.
Yes.
Okay. Then at this time, do either parties have anything further before we go to closing?
No.
No.
Okay, then Mr. Allison.
May I proceed?
Yes, thank you.
First of all, thank you for your time. Thank you for your attention. To say that this has been acrimonious at times, not the proceedings per se, but in the community is a massive understatement. It takes real fortitude, and so I thank each of you for your fortitude in staying the course, following what's required according to the city's charter, and being willing to hear some hard truths. And it leads us to a moment where there is a very serious matter that has really been a cancer in this community for a long time. That's the truth. We have corruption. And it's not words I like to say. It's not something I'm proud of. It's not something I wish we had to deal with. It has been so much easier for years to go along, get along, scratch a back, keep the ball moving. And this group, though, has had the courage to say we have to face it. I have zero, personally, and I cannot be more candid than to just be blunt. I have zero desire to do anything but enrich and improve my community. And it is painful. It hurts to have to face these issues and be the ones to say, that's wrong and we cannot do that anymore. In a criminal case, and again, we've said 1,000 times, this is not a criminal case. No one wants for there to be a verdict that sends somebody to jail. That's just putting a life in jail is a hard thing to do. Of course, we're not doing that here. In a civil case, no one wants to, they really don't. Large verdicts or sending the aggrieved family members in a death case home is painful for a jury. No one wants to do that. Just like here, no one wants to really have to deal with the underbelly of this city, which has been the breeding ground for the mayor for too long. It is serious, and it requires serious people, and you have and are stepping up to that task. I mean, no one wants to do it. No one wants to have to deal with a cancer, but we have to. In this case, it is very straightforward. I mean, look at all the things, the fights that have happened in connection with what happened here. It is manifestly evident that bad things, wrong things, inappropriate things, unlawful things, altering of documents, intentional changing of documents that are from a federal website. Federal, they don't like the word document sometimes. Federal writing is the way it is under the statute. That is horrific. And the idea that somebody would go, QOF would come to you all and run through a process and feel arrogant enough that they can do that. I can walk through this process. I get to lie to CCREDC, they said, and lie to Type B and send the lie to the city council so I can get $2 million. That is, in the most horrific way, the greatest offense when you all have such a huge responsibility to protect taxpayer money. And they tricked you. They tricked you at reading one for sure. Shame on them. Let them not trick you again, which is what we're here for now, because Everett Roy is correct. It's never too wrong to make the right decision. And we have to, because what we tolerate, we become. If we don't act, and I say we, because it's we. You've seen me. I don't move. I move one direction slowly and steady, and you have too. If we do not act, we become the problem. I'm going to make sure I don't take too much time. And I'm going to avoid some of my slides here for a minute because it is so important to just be honest about it. If we do not act, we become the problem. And we cannot do that. It has hurt this community too hard for too long. And what do we know? We know that Philip knew. Of course he knew. He lies to you and he says, I'm an architect. I've been here all my life. I do all this work for the city and I had no idea about floodplains. You are killing me. Golly, if you really knew him, that man could not take a risk for litigation if his life depended on it. It's in a floodplain, it's in a flood. You're going to have to raise base elevation. He told him, of course he did. And he went to the CCREDC meeting, and of course he told the mayor. So of course she knew from the beginning. Even if you give her the benefit of the doubt of all the phone calls in the record, I think there's about 100 of them. We just focused on the ones that are closer in time to certain critical dates. Even if you say that Philip and Devin Bachta didn't tell her, we know from the beginning of the CCREDC process when they voted on it, she knew. She knew about the lie. She knew when it says in the application, quote, newly defined, that's a lie. We know when you look at the slide, it was intentionally offered, not according to Doug, but according to police, according to the independent evaluation, according to every one of yours common sense. I know you know it was intentionally altered, and they removed dates specifically to give it the appearance that it was not published in advance of their project being conceived. That is certain, and she, the mayor, knew about it. She was told about it. And we know that they persisted in the lie that she aided, the fraud that she aided through the CCREDC process. We know they perpetuated it because we have it on videotape. Philip says, FEMA, 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 FEMA. And we know that he used a slide, altered slide, forged slide, because he intentionally altered it. We know that he did that fraud. It's certainly, we're not here on the criminal part of it, but it is certainly civil fraud, which is defined in the paperwork you have, an intentional misrepresentation. You've already found that it is essentially fraud by your finding that they were in default of the agreement with Type B board. That fraud got perpetuated through CCR-EDC through type B, and then came here on a first reading and was continued. You all, not you all, but that council was lied to at the time, relied upon that false representation, relied upon the false slide, which is the definition of fraud in the paperwork before you. And you voted to approve it in reading one. Then they got caught. And then everything changed. But before that, let me make sure I say this on reading one, because what we know happened is that the mayor, it's on video and you've seen it, she is the only person who took that $2 million for her friends by the hand, starting at CCRDC, walked it through the process, came and sat in that chair right there in council on February 20th, 2024, and said to Michael Hunter, it changed. FEMA changed. It changed. It changed. Even though Gully had told her the exact opposite in November of 2023 to her face. She came in and she advocated for that which she had specifically been told was false. And then when Ajit David brought it to light, what do we see? 14 phone calls in one day before they withdraw it on February 27th because they realize, Peter realizes there's a fraud? And he sums it up this way. Let me see if I can play this.
The requested information I asked from the applicant. I don't have that, but they haven't given it to me. And so until then, I'm not giving any recommendation. I'm putting it on the agenda. I was asked to, so you can consider it. You have to come up with your own recommendation.
Got it. But you did you did let the city council know that there were some some improper information, some tampering and all that involved. Also, you let them know.
I let them know. We're going to let them know again tomorrow in executive session. I already have an executive session posted.
Okay. Peter, when does executive session happen? Does it happen towards the end or?
No, when we break for lunch, most likely. I can't remember how many items are on there, but probably on the first break, the lunch break. So like
Is it
2:30? Yeah.
Okay. Is it after public comment or before?
Oh yeah. No, it's after public comment.
Okay, no problem.
Yeah, after public comment.
Yeah, I was just a little surprised that council is still willing to consider this after they know what was done. And on that website, on the FEMA website, it even says this is a United States government portal.
Yeah.
On the very top.
Yeah, definitely. Right. It was altered. And then when you read the entire PowerPoint, it's so obvious that the reader or the writer wanted one to be led to believe that the FEMA was just recent, even words like recently released and this and that. And part of it goes back to the narrative. Mike Culbertson said, hey, we can't, this has to be tied to infrastructure. And so then they catch the scheme that, okay, FEMA floodplain, that's infrastructure. The fixing the bottom floor so it meets the floodplain, and they stuck with it.
Got it.
And then they develop a narrative to fit it that they just found out, because people would say like, shit, they should have known about this a long time ago.
Yes.
Like Councilman Hunter. So I think, Ajit,
Here's where you need to be praised because it's so difficult. It was learned, it was figured out what happened a long time ago. Okay, but this community tolerates and we become. If we continue to tolerate, all we do is, just next time we might as well just say, hey, I know you altered the document. I know you forged it. I know that's a crime. I know that it's wrong, even if it's not a criminal act. I know that it's fraud. I know that you want your $2 million. I know you're my friend, and I'm going to give it to you. We cannot be that. and the mayor was told by Zanoni in no uncertain terms. He said it several times in his testimony. And the mayor was told by Ajit in public comment, and the mayor was told in executive session, and the mayor was told again by Ajit, and the mayor was told again by Ajit's email to her, and it was spelled out in another email. All of this is in evidence by Ajit to Peter Zanoni on May 7th. And what does she do? She gets in her deposition and she says two things, both of which were a lie, either one of which is perjury. She says, I wasn't kept in the loop. I don't know how much more you can be in the loop. And she said, I had no idea there's anything illegal. Well, I guess what the definition of is. Oh, well, no, it said the word illegal. I mean, just because I got told from the mayor's perspective, just because I got told at CCR-EDC that it was false, okay, just because I knew they were getting $2 million based on a false statement, just because now it's getting revealed that they altered a slide, well, no one said anything was bad about it or illegal. Shucks. She has two choices, both of which qualify for removal. She's either just grossly incompetent, really you just have to be incompetent to be removed, or what's more likely is she participated clearly in the malfeasance. She participated by advocating at CCR-EDC. She participated by seconding the motion. She participated while she was violating her oath of confidentiality by texting Devin Bhakta when there was a closed meeting and by getting on the phone call with him for 14 minutes. And you are absolutely and should infer that she, of course, talked to him about what happened at the meeting. That is your prerogative as the judges, is to infer. There's a definition of circumstantial evidence in the documents in front of you, and you are free to make the inference that she talked about what happened at that meeting on November 9th after she left it and probably told Devin, we didn't get a vote for $1 million, but don't worry, we're going to carry it on. Of course she talked about confidential information, aiding, promoting the fraud. And then she came in front and sat in that chair and said to Michael Hunter and everybody, knowing it to be untrue, she said, it changed, it changed, it changed. And then when Peter said we have a problem, what did she do? She said, I want it on the agenda anyway. We're going to give my friends $2 million. I want this project that cannibalizes, doesn't qualify. I want this project that's given it twice as much as it could get under the model of the CCR-EDC in terms of dollars, doesn't qualify. I want this project, she said, that has low-paying jobs compared to what we normally give awards to. I want this project that even though it's already coming, in the words of Everett Roy, it's already coming. And if you look at the emails, they say, yeah, we're still coming. We may have to finish out the shell on the rooftop bar later. It's coming. She wants this project that does not qualify for any of the reasons that you are supposed to award an incentive award. And she kept promoting it. And when she was told, don't put it on the agenda, and I don't recommend it by Peter, she said, I want it on the agenda anyway. And she got her way, because that is the power of the office of mayor, and that is abused by this repetitive conduct. I think I've spoke to all three of the articles. She was aiding a fraud, and that is incompetence. It is neglect it's a willful neglect of her duties. It is malfeasance. It is misconduct to aid somebody getting $2 million in taxpayer money knowing there's a false narrative and a false document. That's article number 1. She's committed perjury by lying acting like she didn't know when of course she knew what the results of the investigation were. And of course she knew there was illegal or wrongful or inappropriate conduct, and don't let them parse words. And of course she knows when she's at the CCR EDC meeting, she's not supposed to leave there and call her buddy and give him an update. On those articles, respectfully, follow the evidence, make the hard findings, and she should be removed, because if we don't, she laughs her way to the next. And what we tolerate, we become. I'm going to reserve some time. Thank you.
Thank you, Mr. Allison.
May I proceed? No, I'll wait till my clock gets up.
Yes, thank you.
Thank you. We have spent days hearing evidence about events that happened more than 2 years ago, and now all that evidence comes down to something very simple. And there were 4 articles, now there are 3. Petitioners brought them, they have the burden to prove them, and after all this evidence, you're going to ask yourself one question on each one. Did they prove it? And when you do that, what you do is you use the jury charge. And that is the document that's been handed to you. After all of this evidence, you're going to ask yourself that one question. It all started with that altered screenshot of the FEMA press that was turned into a PowerPoint slide and the narrative it supported. The mayor did not create that slide. She didn't create the narrative around it. She didn't prepare the presentation. She didn't write the agenda memorandum. And most importantly, where is the evidence that on February 20th, she knew the false narrative that is the key to the case? And I want you to go straight to question number 1, because there's a reason why the petitioners brought Dr. Gully to you in rebuttal, because they didn't meet this in their case in chief. And that is, did she aid a fraud because of and if you read the last sentence on question number 1, on that last part of it, it says, alleged need for complying with newly defined FEMA flood maps and or altered FEMA screenshot. That was the narrative. And the narrative was informed by this altered screenshot. And there's no doubt that that screenshot was altered for sure. Dr. Gully declined to testify that that narrative was discussed. That's the fraud. You just saw him this morning. He said, no, the narrative wasn't discussed. What he discussed was that FEMA maps had changed in 2020. And also, you heard counsel a few minutes ago say that on February 20th, they tricked the council. Well, yeah, you sure did. You heard, and you have it in your record, what Mr. Pusley said about it, what Mr. Roy said about it. Obviously, we know what the mayor said, but also remember, you know that Mr. Culbertson was standing right here, and when the mayor espoused this false narrative that she had been sold in the agenda memo, and said it changed, well, we weren't here, we're at the RTA building, it changed. Mr. Culbertson said, yeah, it changed. And so the idea that she was promoting a false narrative on February 20th would require you to have a witness who comes and says that she was informed of it before that, and Dr. Gully couldn't do that. He was incapable of agreeing that she was told about the false narrative. So on question number 1, the answer, because it's dependent on that, the answer is no on question number 1. And think about it. If the false narrative was really actually discussed at the EDC meeting, really? They approved a false narrative for $1 million, $43,000? What are we doing here? We've got a whole board over there we got to talk about. So we know that cannot be the basis of this aiding the false narrative. Gully was a swing and a miss. There's a reason they brought him. They don't meet. And the reason I bring that up is that, again, I suggested a minute ago, What you have to do is you got to look at each one, and you got to think about all the evidence that you've gotten. You've gotten a lot of evidence, and you got to say, where is it? You got to be able to point to the thing that proves, by a preponderance of the evidence, that she can be removed from office or suspended or disqualified or censured for promoting something that counsel even agrees and admits the counsel got tricked on. And Mr. Culbertson agreed. Oh, yeah, no, it changed, yeah. So, that is, plus there's also a very important part, and the definition of fraud is included in your jury charge. And I'm going to recommend to you that when you go back, get the jury charge out, read it all through. What usually happens is you, in regular cases, we get the jury, oh, I can't see my clock. Thank you. Sorry, I apologize. Thank you. You just read the whole thing through. And so one of the important parts about fraud is that there has to be reliance. And I know that you've already heard about that. You heard about that from Daniel Ray. And I just will say I empathize with the issue of, we got to be able to do something about this. And I know Councilwoman Campos said something about that in her statements that I brought up earlier. And I understand that. But fraud is fraud. And you're working with a legal definition, and the definition requires reliance. And we know there was no reliance because the Type B board did not recommend the incentive based on the narrative. We know that. She came and testified. Mr. Roy agreed. That was not the reason for it. And so the causal connection between the false narrative that existed, there's a break in the causation between that, what we lawyers call break in causation. There's not a connection between that and the incentive. And so a bad slide and the narrative it supported, not done by the mayor, not promoted by her. Once it's found out, there's an investigation, and an investigation that by all accounts, everybody agrees that it was not completed by April 23rd. We know that. In fact, there were motions made here to complete it before there was ever a vote, which takes us to question number 2, which, and again, when counsel just now argued the perjury thing, he didn't bring up the jury charge. Let's pull up the jury charge. Let's take a look at it. Question number 2, did Paulette Guajardo, while testifying in her official capacity as mayor, perjure herself on August 6th, that's the date of the deposition, by stating, so I think what you're telling me is that during that time frame, which is not defined, so you are being asked to guess, I guess, what that question is, you were not in the loop as to what the findings were for the investigation. I do invite you to read that deposition. Officer Garcia, Corpus Christi Police Department, if you look at the police department records that you have, he spent August 8th, 9th, and 11th, or maybe it was October 8th, 9th, I'm sorry, I'm getting my dates mixed up, 8th, 9th, and 11th of October 2025 reading that deposition. And take a look, because what you find out when you read the entire deposition is that the word findings was entirely consistent with the term conclusions that was used by the witness over and over and over again. And so the question, so I think what you're telling me is that during that time frame you're not in the loop as to what the conclusions were for the investigation. Well, that's a completely different question. And the question, I mean, it's not a completely different question. The word findings was absolutely, it's an easy inference to take from the testimony that obviously what she was referring to is, well, no, there were no conclusions. We all know that. I mean, that was said by Mr. Zanoni and by council members on April 23rd. Also, we know that on April 16th, it wasn't complete. In fact, that was the whole point of maybe we should delay this thing and so they can complete the investigation. So whether or not there were findings on April 23rd when that vote took place or before, we know that there weren't. Were there facts? Yes. Were there things that they were learning? Yes. But were there findings or conclusions? Absolutely not. There's no evidence that there was. There's zero. So next question, and again, I'm on page 6 of the jury charge. Question number 2. So therefore, you had no knowledge that it was something illegal in the process that you were voting on. Again, I invite you to read read that deposition, because in the context, illegal was a finding or a conclusion of illegality, and there wasn't. There simply was not. The idea behind the petitioner's theory is that when she denied knowledge of this criminal wrongdoing that was discussed in depositions in 2025, that they tried to put their own conclusions about criminal findings, they tried to shove that in her mouth, and that she simply refused to do that. And so that is not perjury. That is, and I talked about that in my opening. That's a witness using the correct language that, no, I had not received any findings, and I hadn't received any conclusions. So the answer on number 2 is that no, she did not commit perjury by answering those questions that way. The facts indicate that she didn't. 3 is an interesting question. And so what it is we're now down to a phone call and a text message. And the proposal is that a sitting mayor popularly elected, is removed from office for that text message and a phone call. And that is something I hope this body takes very, very seriously and strongly considers what that means. And what you have to do is you have to understand that the confidentiality agreement was not broken. They want you to believe that there's something sinister about a text message by an EDC member asking, what is the economic impact of your project? And telling him his item is on there is not anything he didn't know already. Also, the EDC is a membership board. Every member gets an agenda that tells them what's on there. And so what you have to do, the text messages were, what is the economic impact of your project? And so it wasn't, hey, the board is leaning this way, this is what's happening in our meeting, here's what everyone said, this is what people are saying. What is the economic impact of your project? That question does not reveal confidential information. He didn't respond. It seeks information from the person who already possesses it, and then they point to a telephone call. And they ask you to assume. They ask you to assume. You can't. When there is evidence, you can't assume. Our system doesn't decide cases on assumptions, it decides them on evidence. So, ask yourself, what is the evidence? There is exactly one witness who testified about the content of that conversation, and that was Mayor Paulette Guajardo. She was asked directly whether she revealed what happened during the EDC meeting. I mean, what happened, she was asked directly whether she revealed to Mr. Bacta what happened during the EDC meeting, and her answer was a very simple one. She said, I would not have done that, no. That's evidence. In fact, it's the only evidence you have. They could have subpoenaed Mr. Bacta to come in here and ask him a bunch of questions about that. They chose not to. There is no inference available, and you are allowed reasonable inferences. However, when there's direct evidence of something, you can't. So there is direct evidence in this record about what was said, and it was not whether she discussed what happened. That's the only evidence before you about what was actually said. That's it. There is no other evidence. There's no witness who testified that she disclosed confidential deliberations. There's no document showing it. There's no text message revealing it. There's no recording, no email, no admission. And what's interesting, there's no evidence that the applicant did anything differently after that. So that is a pillar of their case, and you don't have any additional evidence than what the petitioners put on in their own case. They could have presented some other evidence about it, like I mentioned earlier, and they chose not to. Instead, they're asking you to replace evidence with suspicion. And that is not how justice works. The confidentiality agreement does not prohibit her from asking an applicant a question. It doesn't. It doesn't. It prohibits disclosing confidential information obtained as a director, and they have shown you that the communication occurred, but they have not shown you that it included any protected confidential information. They haven't. The only evidence is, again, I would not have done that, no. And so they're asking you to reject sworn testimony, not because they proved it's false, but because they want you to speculate. And speculation is not proof in a law, under the law. It's not. Suspicion is not proof. Speculation's not proof. When you strip away the rhetoric and you look only at the evidence, this accusation has no foundation whatsoever. So the answer on question number 3 is no. Answer whether or not the text message and phone call on November 9th with Devin Bogdan, the November 9 one, was whether that disclosed EDC confidential information. There's no evidence to answer yes. The easiest thing in the world is to punish someone that you've already judged. The hardest thing to do, and a brave thing to do, is to lay down that judgment long enough to listen, and really listen. And that is what due process requires you to do. It is humility made into law. And it asks only one thing. Do not decide first and then listen later. Because in that situation, the hearing is over before the first witness ever even takes a stand. And if that happens, we haven't removed a mayor. We have removed the promise that justice belongs to everyone, all of us, every one of us. So, before you cast your votes, I want to ask you to think about something larger than Paulette Guajardo. I want to ask yourself, how much evidence is it going to take for a handful of elected officials to remove another elected official from office? Because whatever rule you create this evening does not belong only to Paulette Guajardo. It belongs to the next mayor and the mayor after that, and it belongs to every person who ever accepts the responsibility of public office in this city ever. And ultimately, it belongs to the people who elected them. And you have heard words in this proceeding that would frighten any public official. Fraud, crime, perjury, malfeasance. Those are powerful words, and powerful words require powerful proof. Not suspicion, not biased assumptions, not... When we finally get past the words and ask a simple question, what did she know? What confidential information did she disclose? The answers aren't there. There is a temptation in a case like this to say, well, you know, something went wrong, and there's no doubt things went wrong in this. There was an altered FEMA press release. There was a false narrative. There was confusion. And there were questions that should have been asked sooner and resolved sooner. There were people who could have handled things differently. A lot of people who could have handled things differently. But government is run by human beings. But that's not the question you promised to answer when you took your seats as judges in this proceeding. The question is whether the evidence in this case proves that the mayor committed the acts in this jury charge. And you're limited to those that are in that jury charge. And there's a difference, a profound, profound difference between saying something went wrong and saying she did wrong. That distance can only be crossed by evidence. That's the only way you get from something went wrong to she did wrong. And it's not suspicion, it's not association, because that's what a big part of the petitioner's case is. It's just association. It's not hindsight. It's not because she knew somebody or because she voted for something. It's not because someone donated her campaign. What you have to do to make that bridge, to bridge that, is evidence. And if the evidence does not carry you across that distance, your duty is not to finish the journey for the petitioners. Your duty is to stop right there, because that's what the situation is. There is no shame in saying an accusation was not proved. There's no shame in that. There is honor in it. Because the hardest exercise of governmental power, and one of the things that is remarkable about this, is this is an incredible potential exercise of governmental power, and an amazing exercise of power that you have in your hands. The hardest exercise of governmental power is sometimes refusing to use it. You were not elected to protect Paulette Guajardo, and you were not elected to punish Paulette Guajardo. You were elected to protect something much more important. The integrity of the office you yourselves hold, and the right of the people of Corpus Christi to choose who holds it. The voters gave Mayor Guajardo the office. You have been asked to take it away. If you're going to do that, then when you leave this chamber tonight, you must be able to say something much, much more than I suspected. I wondered. I had a feeling. I thought, maybe. You have to be able to say, I know exactly what she did, and I can point to the evidence. In my opening, I said, you're going to need to be able to look at it and point at it and show it. If you cannot say these things, and you cannot, based on the record that the petitioners have tried have attempted to get into this record, then the answer to the questions is not a difficult one. It is no on every single one of them. And it's a no on every single one of them, not as a favor to Paulette Guajardo, not because you agree with her, not because you approve of every decision she's ever made, or any decision she's ever made for that matter, but because that is what the evidence requires. That's what you're limited to, the evidence. And you're told in the instructions, do not let bias play a part in your deliberations. None. Zero. It cannot play a part. And because when the evidence ends, accusations end with it. And you have to go by evidence. Question number 1 is no. Question number 2 is no. And question number 3 is no. I want to make sure, because we did some renumbering, I want to make sure I've got my numbers all right there when we worked on this earlier. After you retire and you go through this charge, and counsel's going to get up and make another argument, I will invite you to leave the final judgment about Paulette Guajardo where it has always belonged, with voters. And I'm going to take a personal privilege here for a minute, and I'm going to read. These are cards that I keep in my pocket that I give out sometimes, and it's one of my favorite quotes. It is, "If we have no peace, it is because we have forgotten we belong to each other." Mother Teresa said that. And when you go back and you assess this evidence, I invite you to remember those words. And I'm saying this kind of as a citizen myself too. Peace. If we have no peace, it's because we have forgotten we belong to each other. My opposing counsel thanked you at the beginning, and I want to thank you too. And I also, at the beginning of this, you might remember I said if any of you were sitting over here, I would proudly represent you. I think I'm kind of reconsidering that now. And it's not you, it's me. I'm just kidding. It has been an honor. It has been an honor to be part of this proceeding. And I do want to thank all of you for your service to this city. I hope that you have understood my job throughout this project and what it is that justice required of me. I'm actually going to give some of my time back. But again, if you look at the evidence and you don't use suspicion and you don't try to use maybes, but you actually look at what was proven through the evidence, the answer to every single one of the questions is no. Thank you.
Don't short me now.
There should be 10 minutes, 30 seconds remaining on the petitioners.
Thank you. And Ms. Huerta, I'll tell you in just probably 60 seconds, I'm going to be going to this, maybe 30 seconds. Thank you. I'll wait for her to get set. Okay. Thank you. You were just told that you're not here to basically judge or to punish or to protect Mayor Guajardo, like it's somehow not your job, and he refers to the voters, let the voters, you've heard that theme at different times, let the voters decide. Let me be very, very clear. The answer to that is, or their supposition, let me say it this way, is absolutely wrong. And let me tell you what I mean by that. You were voted to your office, and each of you took an oath to enforce the city charter, and the city charter requires the removal of the mayor for malfeasance, misconduct, for willful neglect, or for improper conduct. You were elected. The voters put you here. You are the voice of the voters. And this is exactly what you are required to do under the charter, period. Then he said, and I think it's so important, he said, how much, and I'm quoting, how much evidence is it going to take to remove Paulette Guajardo? Because he used throughout his time with you words like speculation, association, suspicion, assume, like there's no evidence. The answer to your question is in the document in front of you. How much evidence does it take? It says it takes a preponderance of the evidence, which means the greater weight of credible evidence presented in the case. And then it says in the document in front of you, you must find that the fact is more likely true than not. If the evidence in the record is that it's more likely, not certain, not beyond a reasonable doubt, this is not a criminal case. If you think it's more likely than not, that's a preponderance of the evidence. And it is way more likely than not that she aided the fraud. It is way more likely than not that she was not being candid and truthful when she gave her testimony. And it is way more likely than not that she violated her confidentiality pledge to CCR-EDC. And then he wants to use words like assume, like there's no evidence on the violation with the CCR-EDC. And the very document in front of you, the charge, says a fact may be established by direct or circumstantial evidence. It's not assumption. It says, quote, a fact is established. I'm reading, by circumstantial evidence, when it may be fairly and reasonably inferred from the other facts. When you have her texting Devin Bhakta during a closed confidential meeting, leaving there after having suffered the defeat of wanting a $2 million vote and only getting Brian Gully's $1.04 million vote, and calling and talking to Devin Bhakta for 14 minutes, it is absolutely correct for you, and he said you can infer finally at some point, it is correct for you to infer that she likely talked to him about what happened at the meeting. Again, quote, a fact is established by circumstantial evidence when it may be fairly and reasonably inferred from the other facts proved. And we have absolute proof of the text messages and the phone calls, and we know what the mayor is capable of when you look at her phone call records from February 25 and 26, when there's 14 calls before the ordinance is withdrawn by the city, only be pushed back on by the mayor. We know what she is absolutely capable of, not remembering anything that would ever be harmful to her, and you may make the right inference that she likely spoke to him. That is a preponderance of the evidence. So there is evidence on every one of the three counts, and the answers to those three questions is yes, yes, and yes, and each one of them support removal. When you want to talk about the evidence, I'm going to go ahead and, ma'am, it's okay. I'm going to go ahead and play. He didn't put in any evidence. I mean, they didn't even hardly call any witness. They didn't even call the mayor. They would have loved an impeachment trial where she didn't answer any questions. Okay?
It's improper argument to suggest she had a burden of proof.
Not true. Please don't.
She had no burden of proof.
So if I give you this definition that forge, like forging a document or writing, that forge means to alter, make, complete, execute, or authenticate any writing that happened, right, so far?
Yes.
So that it purports to be the act of another, like FEMA, that happened, correct?
Yes.
In this case?
Yes.
Who did not authorize it, and we talked about FEMA didn't authorize it, right? That happened in this case?
Yes.
If that's a definition of forge, then the facts of this case meet that definition.
Yes. Yes.
And you know that exact clip was played for Peter Zanoni, and he agreed with it. And what they ask you to do is to do nothing, knowing that there was this forgery, or at least a fraud. There was this wrongful, inappropriate conduct. And they want you to do nothing about it, even though the mayor knew about it from start to finish. They want her to get a free ride. I think one of the comments from Sony even was, to my client, was even that you had told some members of council, hey, don't touch this, something along those lines. Did you do that?
I can't recall if I said that exactly, but I would, let me think how I can say this here. Given what we knew at the time, given the fact that it appeared a federal law had been broken, I wouldn't consider it yet. I wouldn't have put it on the agenda.
We know the mayor's the one that wanted it on the agenda.
After I interviewed Philip, I did that same evening, I believe, have a conversation with the mayor on the phone, and Councilman Pusley was there, either in the room or in a three-way call, I'm not 100% sure. But that was after the meeting with Philip, and so I explained to the mayor that Philip, who would be the only one that could explain what happened to this document, could not explain it. And so there was an obvious change in the document from the website to the PowerPoint. And the only person, well, there were probably two people that could have explained it. One was Mike Culbertson and his team, and then the second one would be Philip Ramirez and his team. And I believe we had a conversation with Mike Culbertson to rule him out and actually ask for a copy of his PowerPoint presentation. And who created it? Did he create it, or did Philip Ramirez create it? And Culbertson said that the PowerPoint was created by Philip Ramirez, sent to Mike Culbertson, who did nothing to change it, and just placed it into a template that had EDC heading on it. That's why we ruled out Culbertson as somebody that may be aware of or may have changed the document, and then started working with Philip Ramirez as the sole person that should know what happened to the document.
And what you just told me is what you told the mayor.
Correct.
Of course they knew. Of course she knew. Of course they figured it out. The same thing that Gully told him back at the CCR EDC. Ajit David revealed the falsity of it. Ajit David revealed the forgery of a written document. And of course they told her. And they told her again in executive session. That's in the evidence. And Ajit David stood in front of her again and told her and gave her pictures of it. And Ajit David stood in front of her again on April 23rd and told her and again gave her pictures of it.
Correct.
And so therefore you had known, I think what you're telling me is during that time frame, you were not in the loop as to what the findings were for the investigation.
Correct.
And so therefore you had no knowledge that it was something illegal in the process that you were voting on.
Right. There was,
Okay.
right.
Okay. She winks at her lawyer. It's on the video, right? It is exactly what Peter Zanoni called it early on. It is a scheme. She participated in it. She promoted. She advocated. She lied about it. She did betrayal of CCR EDC confidentiality. And it's got to stop. What we tolerate, we become. Thank you.
Thank you, gentlemen. At this time, the council will now go into executive session on agenda item 1 pursuant to Texas Government Code sections 551.071 and section 551.074. We'll return. Thank you.
This
Okay, we will call this meeting back in order. And just for the record, there was, in the charges that were delivered, there were some discrepancies between what was printed and our verbiage in the city charter. And so we will be basically defaulting back to the measures in the city charter. And then, Ms. Rebecca, we have the items prepared? Okay.
Yes, ma'am, we do.
We'll go through each of the items, each of the charges first, and then,
May I inquire? I just want to make sure that before you do whatever we're about to hear, that we understand what the errors were so that we can mark our documents and be clear on what's meant when you do what you do.
absolutely.
That makes sense.
On the cover page, in the first section relating to number of votes, this is requiring that 5 members vote affirmatively. According to the city charter, the policy would be a majority, where 5 would only be required for a removal action. So we will be acting on the policy set in the charter. So outside of a removal action, we'll let a majority of the voting body prevail.
And if I'm hearing you correctly, just so it's very clear on the record, you're saying for there to be a removal, it would have required 5 votes. Is that right so far?
Yes.
And for B, which is a suspension for no more than 30 days, that would require 4 votes?
Yes.
And for C, that would be a disqualification from holding further office with the city for 2 years? That would be
Yes.
4 votes?
I will let the record show that that was our second item,
Okay.
where it says A, B, and C on charge 1. C, we interpret as actually being a provision under A. And so we would strike C, and it would be A, B, and then the final option.
Okay, because C, as I understood it, would have been a reprimand option to say you can't run for further office. In other words, you'd be ineligible from running next cycle as a reprimand. Not that it's this, I don't think it's the same as removed from office.
We interpreted through the charter that that language was, one of the options was a removal from office, which would result in a time frame of ineligibility to run. Another option would be suspension, up to 30 days. Another option would be a reprimand.
And did you get advice from the city attorney on whether or not there was an option for a reprimand?
We did.
Right.
Ms. Lisa, could you advise on that distinction?
The charter provides for the council has the authority to reprimand or suspend a member for a period of not more than 30 days if removal is not warranted.
Would under the charter, would an available remedy be a reprimand where you were not eligible in the next cycle?
No.
Okay, that's what I wanted clarity on.
That
Thank you.
section is subsection E, which says a member who is removed from office, whether pursuant to this section by recall or other legal proceeding, or who resigns after any such proceeding has been initiated, shall not be eligible to be appointed to or run as a candidate for city office for 2 years from the date of removal, recall, or resignation.
What I was trying to clarify is, could you not remove but still make them ineligible as a reprimand?
No.
Okay, that's what I wanted clarity on. Thank you.
Okay, and then last, where the options for the 3 different charges use the word censured, we would revert back to the charter that says reprimand.
Ah, okay. Thank you.
Any other questions on that?
None.
Okay, thank you. Okay, so we will, again, as I stated earlier, we'll go over each of the charges and determine whether or not those are determined or will stand. And then we will do vote on the remedy for each of those in sequence afterwards.
Okay, Mayor and Council, on question one. Question one is, did Paulette Guajardo engage in any misconduct, malfeasance, or willful neglect in performance of her official duties by aiding a fraud upon the taxpayers of the city of Corpus Christi related to the alleged need for complying with newly defined FEMA flood maps and/or altered FEMA screenshot? And if you would please submit your vote on that. Okay, so that's 5 to 1. Okay, the second question, if we're ready. Did Paulette Guajardo, while testifying in her official capacity as mayor, perjure herself on August 6, 2025? Question. So I think what you're telling me is that during that time frame, you were not in the loop as to what the findings were for the investigation. Answer. Correct. Question. So therefore, you had no knowledge that it was something illegal in the process that you were voting on. Answer. Right. And thereby commit misconduct, malfeasance, incompetence, or inability or willful neglect of performance of her official duties. Council members, please vote. Okay, so that's 5-1 in favor. The last question, question 3, is did Paulette Guajardo commit misconduct, malfeasance, incompetence, or inability or willful neglect of performance of her official duties by failing to hold all information received from CCREDC activities strictly confidential? And you vote on that, please. Okay, so that's 4-2. Okay, so Mayor Pro Tem, at this point, we're going to go back to question 1 and determine the penalty for that question.
And so do we all understand how that voting will take place? According to the sequence listed, we'll vote each item in order. So question 1.
Question 1 is, 1A is Paulette Guajardo is hereby removed from office. Yes, question 1, the first penalty. If you could vote on that, please. Okay. So that would require 5 votes to pass, so that one fails. Next is Paulette Guajardo is hereby suspended from office 4. And we'd need you to stipulate the number of days if you were interested in that option.
I'm sorry? Should we make a motion to determine the days before voting, I would imagine?
Yes, I would.
Okay.
So that's there, and then we'll vote on it.
Do we have a motion to suggest?
30 days.
Second.
We have a motion and a second for 30 days. I think that's what she's queuing up.
Okay, I think she can. Okay, it's ready. If you'd like to do 30 days, it'll reflect that on your screens. Okay, so that's 5-1, so that one passes. So that makes DEC moot, so
Yeah.
we'll move on to the next one. And that's question 2. And the first one is removal from office on question 2. Okay, so that's 4-2. So that requires 5 votes, so that fails. Okay, next is Paulette Guajardo is hereby suspended from office, 4. And then if you're interested in that option, we would need the number of days.
I think since the first one was
Oh,
set at-
concurrent.
Yeah,
Okay,
so we
gotcha.
can move to the next options under that one. I'm sorry? Okay, we can
You
go,
want to vote on suspension for this charge?
Yeah.
Okay, all right. And the number of days?
do we have this? Okay,
30
motion for
days.
30 days. Do I have a second? Second. All in favor? I'm sorry, you're going to pull the vote up.
Okay, so no. That fails 4-2.
And then we would go, yes.
Okay, and then the last one is Paulette Guajardo is hereby reprimanded for conduct beneath the office of mayor. Okay, so that passes 5-1. Okay, and then on question 3. Question 3A, or E, it says on here, Paulette Guajardo is hereby removed from office.
It's my understanding that one has already been a 4-2, so.
I'm sorry?
Where could you review the vote on charge?
Yes, it
3?
was 4-2.
It was 4-2, so the charge prevailed?
Yes, because it's 4 votes for, the question is 4 votes.
And so now we'll go over each. Is there further question on that?
Yes, does that make sense?
I would object to the removal portion, which is under E, because that would require 5 on the yes, so that's the only reason. That's the,
So that one is what you're saying is that
Well,
one?
the question, we didn't vote on removal for this particular charge. Am I not understanding? So,
the predicate question, which would be if E was selected under this predicate question, the predicate question would have to also have 5 votes because it would be a vote for removal under question 3. So under the charter, you couldn't have a predicate question on question 3. Removal.
okay,
Simply what,
we're going off of what our city attorney advised for that. For the questions were required a simple majority, but the actual removal, when we vote on that penalty requires 5 votes.
I
That's
think
what we were
the vote is
advised.
appropriate. I think we kind of see what probably is going on there, but I think the vote is appropriate.
Okay. Is that all right with everyone? Besides Mr. Flood, sorry.
I'm not sure the proper procedure here, but I think my issue was addressed, and I just wanted to point
Thank
that
you.
out.
Yes, sir. Yeah, we did check with the city attorney on these, so interim city attorney. So on question 3E, removal for the mayor on that charge. Okay, so that fails. Okay, next is Paulette Guajardo is hereby suspended from office, and looks like 30 days is what we've been working with.
I'm so sorry to interrupt, but
Yes, ma'am.
it just realized, could I ask media to be in media box? I'm so sorry. Thank you. Proceed. Thank you,
Okay,
Ms.
I'm
Rebecca.
sorry. Is it ready? Yes. Well, I think we've been doing 30 days. Is 30 days by affirmation? Is that acclamation? Is that okay? Okay. Okay, so that fails. So the last option is Paulette Guajardo is hereby reprimanded for conduct beneath the office of mayor. Okay, so that's tied. So that fails.
Okay, and was that all three? That was all three.
Yes, ma'am. There are just 3. Yes, ma'am.
Okay. Then, Mr. Shamsi, is there any further on your end? Seeing no further business, this meeting is adjourned.